Get ready for the dictation in 3, 2, 1, start. The crux of the defendant's contention is that the alleged agreement is not a valid agreement as there was no consensus of the parties and neither was there any consideration for the same. Stop. The unstamped and unregistered document itself states that it would come into play only if a mutual consent petition was filed by 19th March 2008, and considering that no such petition was filed, the agreement is not applicable to the parties. Stop. It is also the defendant's contention that another agreement was made between the parties which incorporated certain differences and improvements upon the agreement, indicating that the latter agreement was never meant to be acted upon and is therefore not enforceable under law. Stop. The defendants have then submitted various other submissions on merit of the case and referred various decisions, but the same are not relevant for the purpose of deciding the present application. Stop. In the reply to this application, the plaintiff has submitted that the suit filed on his behalf has been filed for various reliefs, including but not limited to specific performance of the agreement. Stop. Therefore, without prejudice to his rights and for the sake of argument, even if the agreement is held to be not enforceable, there are other reliefs which have been prayed for which would need to be considered. Stop. According to the plaintiff, the agreement is submitted to be a spousal agreement which has been acknowledged and admitted by the defendants and therefore the same is enforceable. Stop. Further, the said agreement was signed by both the parties and therefore it is wrong to say that there was consensus between them. Stop. The contention of the plaintiff is that the defendants have filed multiple cases against the plaintiff, being a total of 9 cases in Delhi, India, and 1 case in California, USA, and have been constantly harassing the plaintiff and his family. Stop. According to the plaintiff, despite the interim order restraining the defendants from doing so, the defendant has initiated fresh proceedings against the plaintiff in USA court for the similar relief. Stop. Therefore, in order to avoid oppressive proceedings, the present suit has been filed by the plaintiff. Stop. The details of pending litigation, being civil and criminal, between the parties in India and overseas have been elaborately mentioned in the plaint in para 9 and 5. Stop. In order to determine the present application, it is necessary to refer the plaint wherein there are specific averments as regards the agreement. Stop. The parties then tried to negotiate a settlement with the intervention of lawyers. Stop. The matter was getting stalled on the issue of financial settlement. Stop. This was over several months. Stop. Eventually, the parties met at the residence of a mutual friend and came to an agreement with regard to custody and financial settlements. Stop. It is relevant to mention that the custody arrangement was arrived at on the premise that the parties would be living next to each other in India. Stop. However, clearly that has changed in that they may not be able to live next to each other. Stop. The spirit of the agreement was that the children would have free and unobstructed access to their parents who would together be caregivers. Stop. There was no parenting plan with the plaintiff reduced to a weekend and vacation parent. Stop. On the contrary, the role for him would be that of an equally committed caregiver as the mother. Stop. Needless to say, the custody aspect of the agreement was never even looked at and acted upon. Stop. In the plaint, the plaintiff has sought the relief on the basis of the cause of action. Stop. Thank you.